Good afternoon, everyone, and thanks so much for joining us for this Bracewell webinar involving public entity construction contracts, the pivotal dispute provisions. I'm Phillip Sampson, and I'm here with my colleague, Richard Whiteley.
Good afternoon, everyone.
Richard and I are trial partners at Bracewell, and we're also co-heads of the Bracewell Construction Litigation Group. The two of us have spent more than our fair share of time over the years trying construction cases in front of juries and arbitrators. It's definitely something we both enjoy doing. But one very important thing Richard and I don't have any control over in the construction dispute process is the contract governing the dispute. Now, that's the contract that the parties entered into usually long before the dispute ever reaches our desks. And that contract is usually entered into at a time when everyone is on great terms. Everyone wants to get along. No one is anticipating a lawsuit or even a dispute for that matter. But the dispute-related terms of that contract are critically important. Those are the terms that are going to end up steering the process of any dispute. And those terms will provide limitations and restrictions for any dispute. And whether those limitations and restrictions end up hurting or helping you and your organization depends on how you negotiated that contract up front. Again, at a time long before there was any anticipation of a dispute. Now, in this webinar, Richard and I are going to discuss some of the more important contract provisions that you should pay particular attention to early on when you're negotiating your construction contracts. If you protect your interests and take care of things on the front end when you're negotiating your contract, it will certainly make things go much easier on the back end if someone like Richard or I needs to get involved because of a dispute. But before we get started, I wanted to mention a few housekeeping items. First of all, if any of you has any questions at all as we go through our discussion, please type your question into the comment box on the right-hand side of your screen, and we will get to as many questions as we can at the end of the webinar. If we run out of time for all the questions, we will respond to any unanswered questions in a follow-up email. So don't be shy, please send us your questions. Secondly, this webinar has been approved for 1 hour of MCLE from the state bars of both Texas and New York. If you would like to request MCLE credit, you'll have an opportunity to do that through a follow-up email that you'll be getting from us. So the housekeeping items are out of the way. Let's get started. Governmental entities, as we all know, spend billions of tax dollars every year on construction of public projects. And the public agencies in charge of those projects clearly need to be conscientious about how public tax dollars are spent. So it's imperative that the construction contracts for public projects be negotiated to contain the most advantageous legal terms possible. Of course, during any construction project, time-consuming and costly complications such as project delay claims, defective work, force majeure situations, lien issues, insurance issues, payment issues, indemnification issues, all those types of things can arise. And so well-written contracts that clearly define the scope and the terms of the parties' agreements can minimize the number of claims and disputes that arise. They can minimize delays in the services being provided, and ultimately, they can save public agencies and the taxpayers money. Now, there are a whole host of different important considerations when you're negotiating your construction contracts. And during this webinar, Richard and I are going to focus on the following types of contract provisions. Dispute resolution provisions, mediation and informal negotiations provisions, terms regarding venue and jurisdiction, recovery of consequential damages, indemnity, force majeure, and the process that is involved with change orders and some forms of delay claims. So with that said, let's get the process going.
Thank you, Phillip. So we're going to talk about some general considerations to avoid pitfalls and problems on the front end of when you are getting ready to negotiate your contract. As a governmental entity or a subdivision of a governmental entity, in the bid process, there are some things that you should consider. In Texas, for example, you want to make sure that your bid process complies with Section 2269 of the local government code or the government code. I won't get into detail on that. I'm sure a lot of you are probably aware of those requirements, but it's something to make sure that you do properly on the front end. One important thing that you can do is contain or insert all the important contractual provisions into the bid documents so that when the contractors are sending in their bids, they're agreeing and they're on notice that those provisions are going to be in the final contract. It gives you kind of another arrow in your quiver at the end of the day. If there's a dispute, you should have all those provisions in your contract, but you have the added argument that the contractor was well aware that provision would be in the contract when they bid for it. And it also helps you in negotiations too, because if you come across a contractor who's being difficult about the contract itself and is trying to renegotiate it on the back end, you can simply tell them that they already agreed to this provision when they bid for the contract. One thing to think about is whether you want to have a maximum guaranteed price, a fixed price, or cost plus. So a lot of these contracts are fixed price. Most of them are. I've seen some cost plus contracts recently where basically the contractor proves cost, and that has to be proven to the owner, the governmental entity, and then they add in their agreed upon profit after the fact. If you've got a smaller project, that cost plus, and in my opinion, seems to work a little better than a fixed price. You usually get a better deal. Obviously, you want to try to use your own form. Sometimes in negotiations, the contractor may want to use an AIA form, which they oftentimes will represent as being a standard form. So the AIA forms like A101 or A102, those are not really standard forms. They can be revised. Now, when they're presented to you, a lot of the language is already in them and they look fairly standard. But they can be negotiated, they can be changed. But at the end of the day, the best form you can use is one of your forms that includes all of the language you're comfortable with.
Yeah, and I would jump in to say that the contractors very well may try and push these standard AIA terms on you. And as Richard says, you need to feel free to push back and seek the most favorable terms for your organization, because they aren't necessarily going to be what's contained in what the contractors give you as the standard contract.
And, the AIA forms, that's the Association of Architects, they've been around for a long time, and they've typically been very favorable to contractors. They've come more to the middle recently, and they do have some provisions in them that are helpful to the owner. So if you have a particularly tough negotiation and you have to use an AIA form, they can be modified and they can work. But again, your form will be best. Lowest bid is not always best. Know your contractor. Try to do your research on your contractor. Sometimes there are contractors that try to bid a project very low and then make up for it on the back end with change orders. So always be leery of those low bids. Lowest is not always best. One other really important consideration is to always keep track of red lines that are going back and forth between you and the contractor. If you end up negotiating terms of the contract, contractors have been known to insert changes and that aren't agreed to at the end of the day. And so periodically during the negotiations, you always want to be taking that original form and you want to be comparing it to the existing form that summarizes the state that the negotiation is currently in. That way you can catch anything they've slipped in that maybe you didn't agree to. Obviously, always read the general conditions. most of these contracts have a standard contract, and then they incorporate general conditions. Oftentimes, there's also special conditions that can be negotiated in as well. And in some cases, we've seen instances where only the contract is negotiated and it incorporates general conditions, sometimes general conditions of the contractor, and no one bothers to actually ask for them or read them. So be aware of that, and make sure that if your contract does incorporate general conditions, that they're your general conditions, and that they exclude any other documents that the contractor may have. Hire a good architect. Know your architect. Hire an architect that you have previous experience with. The architect oftentimes is going to be the party, the professional that helps with negotiations, and after the contract is executed, helps resolve disputes on the front end. And so to the extent that you have an architect that you've used before, that you're going to use again, they're going to be more favorable to you than they will be to the contractor. So in looking through contracts, when you're looking at them and reviewing them, sometimes it comes up where you see a provision and you don't really know what it means or don't quite understand it. And sometimes you have provisions that maybe you can't administer. If that happens, remove that provision. Don't just skip over it. And in fact, you should be asking the contractor, what does this provision mean? Why do you need it? And make them explain to you why it's important. And if that explanation doesn't make any sense, then don't let that into your contract. And always, it's helpful to have counsel review and comment, especially at the later stages of your negotiations. And a couple of final points that aren't here on the slide that I'll mention is, if you're a subdivision of a city or the state, or a quasi-governmental entity, one thing that I've seen is you may have a contract with the city or the state or the county, and because you're a subdivision of that city or state or county. And in those contracts, oftentimes the city or the state will require you to make them a third-party beneficiary of any contracts that you have. So keep that in mind. Know what those contracts say and what they require you to put in your contracts with your contractor. And then finally, sovereign immunity. One of the differences with governmental entities, aside from private companies, is that there's the potential that you could have the benefit of a defense of sovereign or governmental immunity on liability or immunity on suit. Nowadays, most courts are not going to allow that type of defense in a construction contract that the governmental entity assents to, especially entities that are political subdivisions of the state that are defined in the government code. But if a dispute arises, you want to make sure to engage counsel to make sure you're not waiving any defenses you might have under sovereign immunity. Nowadays it's unlikely that you would have one, but there are things you can do to affirmatively waive it. So it's always good to include counsel when a dispute begins. For example, if you file suit first, you're waiving any kind of sovereign immunity defenses you might have.
Dispute resolution. So all contracts, virtually all construction contracts, have some language dealing with the way in which disputes will be resolved. And here on this slide, you can see the standard AIA contract dispute resolution provision. There are others, but this is the primary one through which the parties determine or indicate whether they want to arbitrate or litigate their disputes that arise out of the contract. And that's the main question. Are you going to arbitrate or are you going to litigate in court? You'll have that choice. There'll be negotiation. Ordinarily, contractors want to push for arbitration. And what you will hear from them as a justification for arbitration is that arbitration is quicker and it's cheaper, so let's just use arbitration as opposed to going to court. That's not necessarily true, and I wanted to go through briefly what the arbitration process is, and you will see that it is very similar to what you would go through in court, whether through a jury or a bench trial. In arbitration, it starts with pleadings. You have a complaint or a demand and a responsive document as well. Then you have a scheduling conference with the AAA. You then have an arbitrator selection process, which takes a while. You then have a second scheduling conference with the arbitrator where a scheduling order is put in place, much like in court with litigation. The parties then go through discovery just like you would in court with document requests, interrogatory responses, depositions. There is always, of course, expert disclosures and expert discovery that is required in construction cases, just like in litigation. You'll do it in arbitration. There's dispositive motion processes that you will go through in arbitration, and then the hearing, which is the equivalent of the trial. It's a very similar process to what you go through in court. The costs are often very similar, and the duration is also often similar. There's actually additional cost involved with arbitration because of having to pay the arbitrator's fee. You don't pay the judge's fee, but you do pay an arbitrator's hourly rate ordinarily, split by the parties. And with arbitration, you don't have a right. You can appeal, but you're not going to win your appeal. There's essentially very little room to appeal a decision that you don't like in arbitration. So you're stuck with what you get. If you get what you want, that's great. If you don't, that's a problem because, again, there's not really a good appellate prospect for a case in arbitration. But again, contractors ordinarily will say, hey, it's quicker, it's cheaper, let's use arbitration.
One thing also contractors don't like is they don't like their disputes with well-regarded and respected public entities in the newspaper. And when you're in arbitration, that's not going to happen because it's confidential. The last thing a contractor wants is to have the newspaper reporting on how there's construction defects at a university or the local elementary school or some city park. That makes them look bad. It affects the jury pool, and they try to avoid that. And another reason to try to have a jury, try to have a litigation clause, is that gives you leverage over the contractor because they don't like to have their dirty laundry aired. If you do end up using an arbitration clause, one thing to consider is to read it and make sure that it explains the process that you would go through. And obviously with a litigation, you would follow the rules of evidence, you'd follow the rules of procedure, and those are all set forth. In an arbitration, you can make your own rules, and sometimes parties will try to do that. Sometimes it'll provide for 3 arbitrators. Sometimes it'll provide for arbitration to occur somewhere besides where the project is. And so if you do have to agree to an arbitration clause, just make sure you read that and make sure that everything is okay.
And it's not necessarily that Richard and I think arbitration is the worst thing ever, because it's not necessarily. It's just not necessarily the best thing for an owner with respect to disputes. And one of the reasons is because for whatever reason, the arbitrators that we see as part of the AAA or even JAMS or other organizations, they seem to potentially be construction contractor lawyers in their former lives. So there may be some bias there, which of course we wouldn't like. And secondly, you can understand this, contractors they're like the repeat customers in arbitration. Contractors are always doing construction contracts, which often have disputes, so they find themselves in arbitration often. And they're the ones paying these arbitrators because they're always in arbitration. And so to an arbitrator, they almost seem like repeat customers who maybe, you hope not, but maybe the arbitrators might have a little bias toward because they may see them again, as opposed to an owner who doesn't have projects all the time where they're going to be in arbitration all the time is not necessarily a repeat customer.
One last thing is if you're in a difficult negotiation, potentially you have a contractor that you really want to use, and so they have a little bit of leverage in the negotiations, and they're really insisting on arbitration, and you're insisting on litigation with a jury. A fallback position would be to suggest just a jury waiver, where you're in court, and it's just the judge that's going to be making the decision, and both sides agree to waive a jury. That at least gives you it eliminates the confidentiality. Eliminate some of the cost because the judge is paid with taxpayer money and you don't have to pay their fees.
And the final point on the slide, it involves a loser pays provision. This is essentially a provision that says that if there is a dispute that goes to arbitration or a litigation, then the loser will pay the fees and costs to the winner at the end of the dispute. And so that making sure there's a provision like that helps make sure contractors think twice before they initiate a dispute. And as a defendant, if you didn't do anything wrong, it allows you to get your fees and costs back to the extent that you prevail.
Mediation and informal negotiation. So mediation, as many of you know, is a voluntary process that can be agreed to in the contract. It's not binding like arbitration would be. It's a dispute resolution procedure where a third party is involved. So most of these contracts require mediation as a condition precedent to arbitrating or litigating. In other words, before either party can go run to the courthouse or to an arbitration panel and assert a dispute, they have to mediate their dispute. Some of these contracts even have another condition precedent that before you can even mediate, you have to do informal negotiations and what the AIA calls an initial decision situation or an initial decision maker. Sometimes that initial decision maker is the architect. Sometimes it's a third party. In my experience, these procedures just delay your ability to assert claims against the contractor. Certainly, it makes sense to have some informal negotiation, to potentially have a mediation, to try to come to a resolution. But a lot of these clauses have wait periods, sometimes as long as 60 to 120 days, where you have to go to the initial decision maker, make your claim. The other side gets to respond. Then the initial decision maker has 10 days to decide who is right and render his decision. Then after that, you have to wait. You have to negotiate informally. Then you can go to mediation. And then after all of that is over, you can assert your claim in arbitration or in litigation. So I found that can frustrate owners and governmental entities because it is so long. So when you're negotiating these contracts, keep that in mind and try to shorten those deadlines. Another problem that I've seen with mediation early on, it's the best of intentions, certainly. But on these construction projects, oftentimes the contractor is going to pull in subcontractors and other groups that are out there at the construction site because they're going to blame them for whatever you're complaining about on the project. And so they'll try to pull all of those entities into the mediation. And that causes these mediations sometimes to not be effective because a lot of parties show up. They haven't gotten their insurance carriers on board. They're not ready. There hasn't been any exchange of documentation. And it's frustrating. You end up in a mediator's office and you've got 10 parties and 5 of them aren't ready to settle and you don't have all the documents you need and they don't have all the documents that they need. So be thoughtful when you're looking at these mediation and informal negotiation clauses. Try to have short deadlines, maybe provide some kind of a mechanism for a little bit of document production to happen, and maybe limit it to the contractor and the owner.
And on the informal negotiation side of this, it's not unusual to see provisions that require or that at least provide for the possibility of a business person to business person meeting to try and resolve things before mediation happens or before you go into arbitration or litigation. And those are not bad provisions to have. Not that it's necessarily going to resolve the matter up front, but it can be cost effective because you just have a couple of principals sitting down with kind of confidentiality, not waiving any rights, and seeing if business person to business person they can negotiate a resolution. Sometimes those are asked for in these in proposed contracts, and they don't always work, but they're not bad provisions to have.
And this also goes hand in hand with what we discussed earlier: is know your architect, like your architect, because sometimes, especially in the AIA context, that architect's going to be the first person that tries to resolve your dispute, and you want them on your side. So venue and jurisdiction, this is fairly obvious, and frankly, some of it's dictated by the government code anyways, and by the venue statutes and the Texas Rules of Civil Procedure. And so with that being said, you certainly want to check your contract. You want to make sure that the contractor agrees they're not going to challenge venue. You want venue. You want to be the home team. You want it to be in the same county that the project is, the same county where you're located. And it goes hand in hand with the dispute resolution clause we saw earlier. If you're litigating especially, you want the citizens of the county that you're in to be deciding your dispute with the contractor.
So most construction contracts, whether they are AIA-based or non-AIA contracts, include a provision limiting in some form or fashion consequential damages that can be recovered by the parties in the event of a dispute. Now, consequential damages are injuries or harm that result naturally, but not necessarily, from the defendant's conduct. And examples of that would be things like lost sales or lost profits. Those are damages that, for example, if a project is delayed, an owner might lose sales depending on the circumstances, but maybe not. Maybe the owner has some other way to make the sale, some other location where they can get their work done. So you may have lost profits, but not necessarily. That's why it's a consequential damage. Direct damages result naturally and necessarily from a defendant's conduct and can be foreseen. They're foreseeable. They're directly traceable. So, for example, work that a contractor does that is defective, that work has to be replaced. There's a cost to replacing that work, and that is a direct damage to the owner who needs to pay those costs to fix that work. These clauses, I would say, generally help the contractor because usually the owner has a business that they're going to be using their facility for that's being built, and delays or other issues that come up that keep the owner from being able to utilize the building can harm them long term with profits in the business that they intend to do. And those types of injuries and harms are cut off with these consequential damages provisions. But of course, it can also help the owner to the extent that a contractor wants to claim some kind of lost profits or something outside of their direct harm. Now, owners can try to minimize the limitations impact on them by specifically stating in the contract that certain events or damages or circumstances are contemplated in the contract as kind of part of the project. You can do that in the AIA contract anyway through the project description box that is in the contract. And the case law says that by definition, if particular damages are specifically accounted for in a contract, then they are direct and not consequential in nature. So you're not necessarily always going to be able to rope in what otherwise would be consequential damages into direct damages by what you put in the description of your project. But you can at least try and make that happen and protect yourself, with the goal being to cut down on consequential damages limitations effect on you and your organization, but keep it in place, of course, for protection against a contractor's claims.
And it's important. So the description of the project on the AIA form is on the first page. And so if you've got your own contract you're dealing with, you might want to put anything that's really important to you about the project on the first page. One example of this that I've come across, a real world example, is we represented a client that was building a new facility, and they were building it next door to their current facility. And as part of their business, it was necessary for them to operate 24 hours a day, 7 days a week. And so they inserted some language on the first page of the contract that said, it's imperative and important to our business that our existing facility be up and running 24/7 for the entire time that the construction was proceeding on the new facility, and that there weren't any interruptions until the new facility was up and running. It turned out that that became very, very important because the dispute arose. As part of the flood mitigation plan that was required for the new construction site, there was a retaining wall built where drainage was diverted to in the event of a storm, and there was a storm. The retaining wall was defective. The retaining wall burst, and water infiltrated the existing facility, interrupted the business of the client for several days, and caused them to suffer substantial damage. In the context of that dispute, the contractor pointed to the consequential limitation on damages in the contract and said, that's next door. That is totally consequential, and you can't recover that. In turn, we used this McKinney case and pointed them to the language on the first page of the contract that said it was imperative that the existing facility stay up and running, which made those damages direct because they were completely foreseeable, and both parties knew that was an important issue. So indemnity, this is one of the most important clauses in the contract, and it's one of the, I think it probably is the number one most negotiated clause that I've seen. At a minimum, the contractor should indemnify the governmental entity, the owner, for claims related to bodily injury and property damage suffered as a result of actions by the contractor and third parties, subcontractors, anybody else that's on the site. It should not be contingent on the negligence of the contractor or the third party. It should be a strict liability situation where anything, any damage, any bodily injury caused as a result of the contractor working on the project or any third party working on the project, they're going to cover that. They're going to pay for it. So bodily injury and property damage is a minimum. You should also try to include indemnities for employment claims. Oftentimes, employees of subcontractors or employees of the contractor will assert claims against the owner, and you want to make sure that those are indemnified. You want to have an indemnification for any violation of the law that anyone out on that site commits. You want to have also indemnity, IP indemnity, to the extent that the contractor or a subcontractor is using plans or any other kind of intellectual property on the site that belongs to some other party. That other party could assert a claim against the owner related to that because it's being used on their project. So you want to make sure that you have that indemnity against IP infringement as well. And separate lien indemnity for subcontractors is always a good thing to have because there's just about every construction dispute I've seen, there's subcontractors that are upset because they haven't been paid and they assert liens, and you want to make sure the contractor is looped into that. So duty to defend. If you can get a duty to defend in addition to indemnity, that can be very helpful too, but you really need to pay attention to what the language is for the duty to defend. And the duty to defend is essentially not only do they have to indemnify you for anything you come out of pocket, they also have to pay for your lawyers to defend you. So if you're able to negotiate for a duty to defend, what you want to be looking for is how much authority you have in hiring those lawyers. You want to try to insert that, and you want to make sure they pay for those lawyers, and you want to also make sure that they're not able to settle or resolve the case without your acquiescence. So one thing that comes up quite a bit is the anti-indemnity statute. And in Texas, it's in the insurance code. It's section 151.001. And what the anti-indemnity statute, and there's also an oil field anti-indemnity statute, and other states have these anti-indemnity statutes, and it's the legislature. The legislature has come in and they've tried to kind of level the playing field, because when you have a situation where one party doesn't have a lot of bargaining position, a lot of times the indemnity is really strongly against them, and you see instances where owners have forced contractors to indemnify them for not only anything they do or any third party does, but also if the owner is negligent or intentionally creates some kind of damage or injury at the job site, the contractor has to indemnify them for that. So the legislature has decided that is not acceptable, and it's been basically outlawed in the anti-indemnity statute. So keep an eye open for that. Your contractor may push back on you if you've got a clause, and they're rightfully doing that, and that clause won't be enforceable anyway. So it's probably good to just relent and have a good indemnity, but don't have a situation where they're indemnifying you for things you do. And the owner is rarely out on the site except for on occasion in most of these instances. So it's not going to really get you anything. So one last thing that I'll mention is sometimes contractors will insert this little clause in an indemnity in regards to property damage, and they'll say that they'll indemnify you for property damage to property other than the work itself. And when you're kind of reading through these indemnity clauses, they're generally very long and complicated. Sometimes that can kind of slide under the radar. You want to remove that because what happens is they'll indemnify you for damage to property, but they won't indemnify you if they do something that damages the actual construction of the project, the materials, or what they've already built. And they'll try to force you to use insurance for it, but it's something that if you see it, you should flag it and you should remove it. So, force majeure. Force majeure helps the contractor. And I haven't seen any instances where it's been helpful to the project owner or the governmental entity. Years ago, force majeure used to be a doctrine, a contractual doctrine that was implied in contracts. Essentially, if there's something that happens to prevent performance of the contract or prevent the construction itself in a construction sense or delays it, and it's some act of God or it's something that's totally beyond the control of the parties, the doctrine would intervene and allow relief to relieve the party that's being delayed or the party that can't perform with any liability for the delay or the breach of the contract. Now this is completely contractual. That doctrine no longer exists. And so the devil is in the details, and the way the clause is worded is extremely important. And so review these clauses and eliminate them. Like I mentioned before, they are rarely helpful to the owner because these acts of God are really just going to affect the contractor finishing on time or not being able to finish, period, and give them relief and eliminate your liquidated damages or what have you. So eliminate it if you can. If you can't, make sure that it is worded very, very tightly. The language used is very important, and you see these boilerplate provisions that people just drop in the same clause to every contract. Make sure it's unique to your project. You definitely should only permit delays for events that are beyond the control of the contractor that prevent them from performing. Make sure that they'll list out all these events like terrorism and acts of God and fire and hurricanes and strikes. And so all that laundry list of examples of what might be a force majeure, that needs to be, for all you English majors out there, it needs to be modified by a clause that says beyond the control of the contractor that prevents performance. So terms like adverse weather, that's a terrible clause to have in a force majeure clause. It's very broad and often abused, especially in Houston, Texas, where we have a lot of rainstorms and floods. You really want to kind of uniquely describe the type of adverse weather.
And regarding weather events, it is not unusual at all for contractors to want additional money for downtime when they are paying their employees, but the employees can't do work because of whatever the weather issue may be. And those are the circumstances where they would either want to use force majeure or get a change order to get more money for the weather event. And one thing I've seen that is very helpful for owners is to try and utilize or implement a contract term that restricts the instances in which a contractor can seek additional money for weather delays by having contract provisions that say, for example, or that require a contractor to kind of build up a certain number of rain days or non-work days because of weather. A certain number of them have to accumulate before the contractor can then ask for delay damages for the next weather event. So maybe it's 15 accumulated rain days or 20, whatever it is. Make the contractor reach some certain level of number of delay days before they can even begin to seek compensation for the delays. And then secondly, include a provision that requires the contractor to utilize weekends as makeup days. So if there are a couple of rainouts, if the contract requires the contractor to use weekend days to make up those couple of rainout days, or else they can't use those rainout days to accumulate the number they need to seek a change order, that's very helpful, and it keeps the contractor on a tighter leash, and it helps restrict the effect of broad force majeure type provisions.
And I've seen in some of these contracts where smart entities have inserted in clauses that require affirmative actions on the part of the contractor if they're going to claim a rain day, or the affirmative thing they agree to do is they have to utilize pumps and drainage to the best extent possible to drain that water off. And they have to prove that they've done that and show the owner that before they can claim a force majeure or a rain day. So one question we've been getting a lot is, are tariffs a force majeure? I'm sure many of you are familiar with the governmental tariffs, the steel and aluminum tariffs, many other tariffs. So contractors, obviously, when their steel or their aluminum they're going to use on the project goes way up in price because of the tariff, they will sometimes try to claim that as a force majeure and say, oh, we need more money, we need a change order, this wasn't expected, it's outside our control, the government did it, and we're not making any profit. So generally, just be aware, a tariff is not a force majeure. Commercial or economic burdens, commercial impracticability, is not going to prevent them from performing. It's going to make it more expensive for them to perform. That is not a force majeure situation, but contractors will sometimes try to use it as one. There's some other articles that we've written that are on the website about that. If you're interested, you can easily find them there.
So for example, the weather delay issues that Richard was just discussing, the way that owners will often see that come through, even force majeure events and weather delays, will be through a contractor's request for a change order to increase the amount of money that the owner has to pay the contractor. Changes to the contract itself are ordinarily done through change orders. And those changes can involve changes to the work that's being done and also changes to the contract price. And the way in which the change order process will go is simply determined by what the terms of the contract say, and it can be written up any different number of ways, some of which are more favorable to owners than others. Contractors, again, as Richard mentioned earlier on, not unusual to see a low bid, and then throughout the project, the contractor submits change order after change order after change order to try and make up money on the back end. Again, that process and the additional money to be paid under the contract, that ordinarily takes place through a change order. Change orders also can extend the substantial completion date for the contractor's work. If, for example, there are weather delays that entitle the contractor to more time to get their work done, there can be a change order to increase the number of days on the project, the amount of money on the project, the type of work that's being done, etc. Now, it is really important that the change order process in the contract be very clear and very detailed, because this is one of the main areas where you see disputes between contractors and owners. Again, it's a way that an owner can end up paying a lot more money than they ever thought they would. And so the owner is going to want the process for change orders to be legitimate, to be pretty detailed and as favorable to the owner as possible. The change order process should include tight deadlines for submitting requests for change orders, because you don't want a contractor to suffer some kind of a setback, whether it's a delay or something costs them more money, and then they sit back for months and then later submit a change order saying, 3 months ago, XYZ happened, and so you really owe me more money now, owner. You don't want that to happen. And so having tight deadlines in place is important. An example of a pretty good change order provision that I've seen owners use requires for a change order to be valid, the contractor has to give notice to the owner of whatever the relevant circumstances requiring the change. Notice has to be given to the owner within 10 days of the contractor learning about that circumstance, so some immediacy there. Secondly, the contractor has to actually submit a change order request to the owner within 15 days of the occurrence of whatever the relevant circumstance is. And that request must contain sufficient support and documentation to legitimize the request. And that type of process, to cause things to happen quickly after the occurrence of an event, it's legitimate for an owner to need things to happen quickly, because oftentimes owners can help the contractor out of sticky situations if the owner just knows about them. And so by requiring a contractor to give quick notice of a problem that may require a change, it allows the owner to maybe try and help mitigate whatever the issue is and help the contractor through it, so that it's not as much of a liability on the back end for the owner to need to make up with a change order. Also, it's nice for the owner when there are provisions in the contract that give sole discretion to the owner about whether work is or is not defective. That's a tough one, because that's very helpful to the owner, but I've seen it and it's helpful. It's also very helpful for an owner when there is language in the contract that allows withholding payment to a contractor in the event of a good faith dispute or defect claim. And for example, I have seen contracts that allow owners to withhold payment to a contractor, even if the payment is otherwise due for work completed, that the owner is contractually permitted to withhold payment if the contractor has failed to provide the owner with schedules, that the contractor is supposed to be following timing-wise, or if there is, in good faith, alleged defective work by the contractor or a material breach by the contractor of terms of the contract, or if there have been overpayments, mistaken overpayments by the owner to the contractor. Those are instances where the owner, if the provision is written correctly, can withhold payment of an otherwise properly payable invoice. It's important that the language for a change order recognize that change orders will not be allowed for circumstances that are within the control of the contractor. Other helpful provisions regarding delay claims are ordinarily there is a duty to mitigate. Under Texas law, under laws of most states, there's a duty to mitigate your harm and damages. but it is very helpful if you can write into your contract that there is an affirmative duty by the contractor to mitigate delays. And here's an example of a provision like that I've seen. The contractor shall not be entitled to any adjustment of the project schedule, including the substantial completion date or an adjustment of the contract price for any portion of delay to the extent the contractor could have taken but failed to take reasonable actions to mitigate such delay. I mean, that provision is very helpful for an owner when a contractor is saying, hey, I need to get paid for a month's extra work because I couldn't get my stuff done. Well, the owner can go back through all the schedules and the meeting logs and whatnot and sometimes show, hey, there's a lot of stuff you could have been doing, contractor, and you just chose not to do it. And you failed to mitigate your delay. And so you don't get a change order for that. That's very helpful. And then secondly, because contractors oftentimes claim delay damages because of interference with their work by other contractors on site, it's important to have a provision that requires the contractor to coordinate its work with the other contractors who may be on site.
So miscellaneous. So this slide is intended to point out other types of clauses that you'll want to have if you use your own form. So the AIA contract will contain all of these, except for maybe the last one allowing an offset. So if you're using your own form, you just want to make sure you've got provisions like these in the contract. One kind of high level thing that you definitely need to include is retainage. It's not on this slide, but super important because that 10% retainage allows you to get the statutory lien protections against subcontractors. If you have that retainage, it also provides leverage for you at the end of the project when the contractor is ready to move on to the next project and you're trying to get them to finish and they don't want to finish. And if you have retainage but they haven't been paid yet, they're going to be a lot more likely to comply with that to get their retainage. What a good amount of retainage is 10%. You don't want to go below that. A couple other things. Sometimes, hopefully you've done your research on the contractor, but you may want to require clauses to allow you to require the contractor to prove they're financially solvent at various times during the project. That's important, obviously. If your contractor goes belly up, then you're going to have to get another one, and there's going to be delays. So that's an important thing to think about including. You want to make sure the contractor acknowledges and agrees that they visited the site, they're familiar with the site, they accept the conditions of the site, they affirmatively represent that they have reviewed all of the contract documents, all the drawings, any kind of subsurface soil reports that have been done. You want them to acknowledge they've seen all that and that they're aware of all of the conditions, because if they don't, then they're going to use that to try to get a change order, a delay order, or a force majeure. You want to make sure the contractor is agreeing that they are supervising and directing the work and is responsible for the construction means and methods. You want them responsible for all subcontractors and suppliers. You want to be able to go to the contractor in a dispute and demand that they fix something or that they, give you reimbursement for issues that are not only caused by them, but also by their subcontractors. You want to make sure, and this sounds a little bit silly, that you want to make sure the contractor enforces good discipline and good order, and not permit employment of persons not properly skilled. But you'd be surprised at some of these construction sites, especially when you're talking about a superintendent. There are personality conflicts that arise, and you want to retain the ability to be able to demand from the contractor, look, we don't like your superintendent. We don't work well with them, and we need you to replace them. You want to make sure they're not performing any work that's contrary to applicable law, and you want to preserve the right to stop the work if you have to, and finish the work they haven't done. You want to provide that ability in the contract, and if you can, get a clause allowing you to offset any amounts that you owe the contractor against any damages they've caused or any amounts they may owe you.
And that's very important, I believe, for an owner as well, because oftentimes an owner, there may be money that's due to the contractor, but the owner believes, hey, I'm owed a bunch of money by this contractor for a bunch of defects and other problems that the contractor caused. They're essentially competing claims, and there may be rights to offset under the law generally, maybe, but why not make it crystal clear that the owner has that right? And so it's very helpful. And an example of that provision that I've seen owners have in their contracts is this: owner may offset. I mean, just come right out and say it. Owner may offset any amount due and payable from contractor to owner under the agreement against any amount due and payable to contractor hereunder. That way, if you go into arbitration or court, you can argue, yeah, I may not have paid some things that could be legitimate, but that's not a breach of contract because I have the right to offset. So it puts you in a much better position, and it's expressly in the contract. You don't have to worry about what the underlying law may be regarding the equities and offsets.
So we have a couple of questions that we'll address, time permitting. So the first question is, what types and amounts of insurance should a contractor be required to maintain? So when negotiating the insurance requirements in a contract, I find it's always very helpful to loop in folks in your risk management department. They're going to know a lot about the types, what's normal. Generally, you are going to want your contractor to have commercial general liability insurance. You're going to want them to have automobile liability insurance to the extent they're operating automobiles at the site. You're going to certainly want everyone at the site to have workers' compensation and disability benefits insurance in case something happens to the employees out at the site. For your design professionals and engineers and architects, you're going to want them to have professional liability insurance. You're going to want your contractor to have builder's risk insurance. And this will work hand in hand with your indemnity clause and should also, work hand in hand with any bonding you have. So again, get with your risk managers and they will know what the levels of insurance typically are standard in the industry. So another question.
There's another question about the importance of seeking a provision regarding liquidated damages in a contract and whether liquidated damages provisions are enforceable. And I can tell you that in our opinion, number one, yes, it's very important for an owner to try and negotiate the inclusion of a liquidated damages provision. It provides leverage against the contractor. It provides some means of offsetting against the no consequential damages provision. And so, yes, it's very useful. Are those clauses enforceable? Generally, yes, but it depends. They just need to be reasonable. They can't be a pure penalty. So $1 million a day, liquidated damages provision probably would be unreasonable and not enforceable. But $500 a day, $1,000 a day, and I've seen $25,000 a day be enforceable. It kind of depends on the circumstances, but the amount simply needs to be reasonable. But yes, those are important provisions to include for an owner.
One other question we had is, does the prompt payment statute apply to governmental entities? So the prompt payment statute is Chapter 2251 of the Texas Government Code, and it does apply to all public contracts. Now, if you go and you read that provision, it does have a safe harbor provision that if a public owner is not required to pay any amount that is subject to a good faith dispute. And so it basically kind of boils down to whether those penalties and interest are applied is at the end of the day, when the dispute is resolved, who is responsible for it. But yes, it does apply to governmental entities. So I see that our end time is coming up, and thank you everyone for your questions, and also thanks very much for joining us today on this webinar. It was Phillip and myself our pleasure to present, and we hope the information that we provided was helpful to you. If you have any follow-up questions or we didn't get to your question that you submitted, please feel free to reach out to myself or Phillip, and we'll be happy to discuss it with you. Have a great afternoon.
And I also want to thank you all for listening in. If there's anything that we can do to assist you with your construction-related issues, whether on the front end while you're negotiating or on the back end to handle a dispute, please just let us know. We'd love to help you out. And again, we appreciate your listening.